judge. Okay, Rep.J. Crockett, that's enough. The court thinks your argument isn't legally sound and is based on your beliefs. Judge Allison Jones Rushing's words were like ice in the packed courtroom. The judge, who's 40 and the youngest ever on the 4th Appeals Court, leaned forward and looked down at Rep.Jasmine Crockett, clearly not agreeing with her. Everyone's phone was recording this nationally broadcast hearing about voting rights, especially a new local law that requires people to show their birth certificates to vote, was getting a lot of public attention. Human rights groups asked Rep.J. Crockett, who used to be a human rights lawyer, to argue their case. For almost an hour, Crockett laid out her argument with past cases, stats, and basic legal ideas, but Judge Rushing, a well-known conservative legal mind who's known for sticking to the basic, interrupted her with what sounded like a decision she'd already made. The room got quiet. Lawyers exchanged surprised looks. Usually judges aren't supposed to say what they think before both sides have finished their argument. The state's lawyer, who hadn't given his side yet, looked up shocked. Reporters started typing away already, writing headlines about how biased the judge seemed. Crockett stood still at the podium for a few seconds. Cameras zoomed in on her face, waiting to see if she'd get angry, annoyed, or discouraged. Everyone expected, maybe even wanted, a fight that would be talked about for days. Instead, Rep.J. Crockett calmly picked up her papers, closed her folder, and looked straight at Judge Rushing. "Your Honor," she said, her voice steady and clear, "with all respect to this court and your position, I have to ask, are you using the standard from Harper versus Virginia or Crawford v. Marion County?" The question, which quoted two different Supreme Court voting rights cases, was asked so professionally that it caught the judge off guard. Judge Rushing blinked, clearly surprised by both the question and Crockett's calm. The room was silent as the judge paused, suddenly aware that her interruption had caused a tricky legal situation. What Judge Rushing said next and how Rep.J. Crockett replied not only changed the outcome of this key voting rights case, it showed legal integrity that people will talk about and law schools will study for years to come. Before we tell you what happened in this amazing courtroom moment, hit that subscribe button and turn on notifications. We bring you the most vital legal battles that are quietly changing how the government works in the United States. The moments when our basic rights are protected in ways that don't always make the news but affect everyone's future. The big federal courthouse in Richmond, Virginia was surrounded by protesters since sunrise that fall morning. On one side, human rights activists held signs that said "protect the vote" and "birth certificates equal poll tax." On the other side, protesters held banners that read "voting integrity matters." At the courthouse, police kept people apart as reporters covered the tense situation. The case, Johnson vs. Regional Ballot Committee, was about a new local law that required voters to show their birth certificates at the polls. Supporters said it would stop fraud. Opponents claimed it would make it too hard for many eligible voters, especially seniors, the poor, and minorities, to vote because they have trouble getting those documents. What made this session really important was the timing. The election was only 6 weeks away, and this region could decide the whole thing. The court's decision would either keep the law in place or stop it before election day, which could affect thousands of votes in a region where recent races have been super close. The case had already been through a lot. A local judge first blocked the law, but then a panel of 3 judges overturned that decision. Now, the full court was reviewing the case, and it could have big effect on very similar laws being considered in other regions. Judge Allison Jones Rushing, only 40, became one of the youngest federal appellate judges when she was appointed in 2019. She went to Duke Law, clerked for the Supreme Court, and worked at a law firm before becoming a judge. She tends to stick to the original literal meaning of legal text without considering the larger social impact. Even her critics admit Rushing is really smart, but civil rights advocates were worried about her lack of experience with voting rights and her ties to groups that had pushed for stricter voting rules. Before this case, she had only written 2 opinions about elections, and both supported strict voting rules. Despite being young, Rushing acted like she knew exactly what she was doing. She asked direct, tough questions, especially if she thought lawyers were making arguments based on strategy instead of the law. Her staff described her as smart but stubborn once she made up her mind. Across the room was Rep.Jasmine Crockett, representing Texas's 30th district, but today she was there as lawyer. Before entering politics, Crockett had a successful career as a civil rights attorney, focusing on voting rights. She went to Rhodes College and the University of Houston Law Center, and has won several important cases protecting voting access for underserved communities. Crockett's success in court came from her mix of legal knowledge and personal understanding of the people she represented. She wasn't just some academic. She had spent years helping real voters deal with confusing rules so they could exercise their basic right. Her case files included hundreds of sworn statements from people who had been kept from voting even though they were eligible and had tried to vote. Crockett's approach to important cases was organized and thorough. Instead of just tugging at heartstrings, she built her cases carefully with historical context, data, and specific legal examples. This approach had earned her respect even from judges who disagreed with her ruling, because she would always give the courts a clear path to rule in her favor within the existing legal framework. So this case was all about Emma Johnson. She's a 78-year-old black woman who's voted in every election since 65, but now she can't get hold of her birth certificate. She was born at home in rural Virginia way back when, and her birth was recorded in some county book that burned up in a courthouse fire in the 70s. Even after trying everything, hiring a family researcher, visiting all sorts of government places, she still couldn't get that paper she needed to vote. And she's not the only one. Turns out around 198,000 registered voters in that area can't easily get their birth certificate, which hits older people, rural residents, low-income folks, and people of color the hardest. The region brought in this rule only 8 months before the national election, barely told anyone about the changes, and didn't offer any support to help people get the docs. The region is saying that preventing fraud is a good enough reason to make voting a little harder. Also, they offered a reasonable alternative, a complicated waiver. To get it, voters have to provide a bunch of other IDs, show up in front of some committee, and sign a statement saying they're telling the truth, or else they'll be punished. The whole thing usually takes 2 to 3 months. 4 experts took a look at what was going on. The big question is how the court would balance the region's worry about election safety with the basic right to vote. Would they use the strict legal test that normally protects voting rights, or the easier reasonable burden test that's let other voting restrictions slide lately? What do you reckon about voter ID laws? Have you or anyone you know had trouble voting because of ID requirements or other rules? Share your stories in the comments. I want to hear about how voting laws affect everyday Americans who just want to exercise their right to vote. As Representative Crockett walked up to give her argument, you could feel the tension in the room. She was wearing a simple navy suit, her hair was neatly done, and she just had a thin folder of papers with her. The place was packed with legal observers, civil rights advocates, and political people, all eager to see this important battle. May it please the court, Crockett began, her voice clear and steady. I'm here for Emma Johnson and all the other registered voters who, despite their basic right to vote and their desire to do so, are being blocked from voting by the region's birth certificate rule. She paused to look each judge in the eye. This case boils down to one question. When a region passes a voting rule that stops nearly 200,000 qualified residents from voting, how closely should this court examine that rule? And what public interest is strong enough to justify such a burden? For the next 15 minutes, Crockett laid out her case, starting with the background. She reminded the court that voting restrictions have changed over time, from outright bans based on race or gender to seemingly fair rules that still have unfair results. She quoted Justice Thurgood Marshall, who said that the right to vote is the most important right in a free society. Judge Williams, who's known to be somewhere in the middle on the court, interrupted with the first question. Representative Crockett, doesn't Crawford vs. Marion County say that preventing fraud is a good enough reason for voter ID laws? Yes, Your Honor, it does. Crawford did recognize fraud prevention as a valid concern, Crockett replied, but Crawford was about a photo ID law with many alternatives for voters who didn't have ID. The court specifically said that the evidence didn't show a lot of registered voters without photo ID. And she turned the page in her folder. We've got solid proof that around 198,000 registered voters here can't get their birth certificate. Crawford pointed out that any requirements need to be reasonable. The state hasn't given any reason to believe that this rule will stop any kind of fraud. Actually, their own election officials said that they don't know of any cases where someone directly pretended to be someone else to vote, which is the only kind of fraud a birth certificate rule could even possibly prevent. Judge Matthews, known to stick to the law, asked, Counselor, doesn't the state's waiver system offer a good alternative for voters like Ms. Johnson? Crockett was ready for the question. The facts say otherwise, Your Honor. To get a waiver, voters have to go in person to county offices, which are only open during business hours, bring a bunch of different IDs, and then wait 2 to 3 months for an answer. For older voters, people without transportation, those who can't take time off work, or people with disabilities, this is nearly impossible. She put a map up on the screen. This map shows where the 11 waiver offices are located in the state. In 27 districts, mostly rural areas with lots of minority voters, people have to travel over 50 miles each way to get to an office. With a 3-month wait time, voters who find out about the requirement close to an election basically have no way to actually vote. For almost 40 minutes, the questioning kept going. Each judge asked about different parts of Crockett's argument, looking at the legal reasons and what it would mean for people. She answered everything accurately, giving specific details, numbers, and stories about how it affects real voters. Then the moment that defined the session came. Judge Rushing, who had been quiet until now, finally spoke. "Representative Crockett," she began, sounding doubtful. "You're saying that any voting requirement, no matter how small, is unconstitutional. But doesn't the Constitution specifically give states the power to decide how elections are run?" It was a classic originalist point. The Constitution gives states control over elections, which is all that matters. "Yes, Your Honor," Crockett replied. "Article 1, Section 4 does give states that control, but that power has always been understood to have constitutional limits. As the Supreme Court said in Reynolds v. Sims, the right to vote can be affected by a dilution or weighting of the citizen's vote just as effectively as by wholly prohibiting the free exercise of the franchise." She went on, "The original Constitution did give states broad election powers, but the 14th and 15th Amendments were passed specifically to protect voting rights, and they changed those powers. As Justice Scalia said in Crawford, these amendments safeguard the privilege to vote without unreasonable burden." Judge Rushing's expression tightened. "That sounds like you're rewriting things to get the result you want. The Constitution is clear about state control." Crockett stayed calm. "Your Honor, I'm not rewriting anything, just pointing out how the Supreme Court has consistently understood this in many cases. In Harper v. Virginia, the court specifically said that the right to vote is too precious, too fundamental to be so burdened or conditioned. This idea has been restated in Anderson v. Calabrese, Burdick v. Takushi, and most recently in Houston, our V.A. Philip Randolph Institute. Judge Rushing leaned forward. "Those cases were all about different situations. Birth certificates are official government documents that everyone has or can get. It wasn't crazy to want to make sure the election was legit. This was a key example." Rushing claimed something that the facts totally disproved. Crockett needed to fix the record without looking like she was attacking a judge. "Your Honor," she said, "the facts found in the local court go against what you're saying." Crockett was respectful. An expert from the area's Vital Records office said that around 7% of people born there before 1965 don't have birth certificates that can be officially verified. For those born at home, especially during that time, birth records were often incomplete or not done at all. She held up a paper. "This document," she said, "from the National Research Council, with experts from all over the spectrum, shows that access to birth certificates varies a lot depending on age, race, location, and money. These documents aren't easy to get for everyone and create special problems for older, poor, and minority voters, the very people the Voting Rights Act is meant to protect." Judge Rushing seemed a little taken aback by the direct correction, but quickly recovered. "Even with those numbers," she said, "the state has a waiver process. Your clients just need to use it." Crockett responded, "The record shows the waiver process doesn't really work for many voters. Ms. Johnson here tried to use it. She went to the county office 3 times, gave them 7 different forms of ID, like her expired driver's license, social security card, Medicare card, property tax bills, and high school yearbook. After waiting 83 days, her request was denied for no reason." She turned to another page in her folder. "The local court found that only 4% of waiver requests are approved, and it takes an average of 76 days. To give you some perspective, there are only 42 days left until the election. Even if everyone affected applied today, most would get answers after the election." The back and forth went on for a few more minutes, with Rushing pushing various legal points and Crockett answering with examples and facts. The tension in the courtroom grew as people saw the basic clash of legal views happening right there. Strict interpretation of the law versus seeing how it actually affects people's rights. Finally, clearly annoyed with Crockett's constant rebuttals, Judge Rushing did something unusual. "That's enough, Representative Crockett," she said. "The court finds your argument legally unsound and politically motivated." The statement given before. "The state even made its case breaks basic rules of court behavior. Judges usually wait until both sides have presented their arguments and the court has consulted before making such calls." The early announcement suggested Judge Rushing had made up her mind before hearing all the facts. The courtroom went silent. The lawyers exchanged surprised looks. The state's lawyer, who hadn't even spoken yet, looked up in shock. reporter started typing fast, already writing headlines about the judge's obvious bias. Crockett stood still at the podium for a few seconds. Then, calmly gathering her papers, she closed her folder and looked straight at Judge Rushing. "Your Honor," she began, her voice steady and clear. "With all due respect for this court and your position, I have to ask, are you going by the standards set in Harper versus Virginia or Crawford versus Marion County?" Judge Rushing blinked, clearly surprised by both the question itself and Crockett's calm demeanor. The courtroom was completely silent as the judge paused, suddenly aware that her outburst had created a tricky legal situation. Crockett's question was expertly crafted. She cited two opposing Supreme Court cases, Harper, which looked closely at voting rules, and Crawford, which was more relaxed. This showed the main legal issue and reminded the judge that any ruling needed to say which case applied. More importantly, Crockett answered with a legal question instead of complaining about a judge. She stayed professional while clearly pointing out the problem. It was amazing legal skill under pressure. After a tense silence, Judge Rushing spoke. "Representative Crockett, I was just worried about parts of your argument, not giving a final decision." Her tone changed, becoming more formal. "To answer you, the court will look at both Harper and Crawford along with newer cases." It was a clear backing down from her earlier statement, admitting she had gone too far. Other judges exchanged glances, and Chief Judge Gregory leaned forward slightly. "Please continue with your argument," he said, calmly taking control back. Crockett nodded respectfully. "Thank you, Your Honor." To address Judge Rushing's worry about local control, I want to point out that the Supreme Court has consistently ruled that while states have a lot of power to control elections, it's not unlimited, especially when it affects basic rights. She turned to a fresh page. Actually, in Crawford, Justice Stevens said that fair rules protecting the voting process are okay, but courts need to carefully look at each situation to see if there's reason to doubt them. For the next 10 minutes, Crockett continued her argument with intense focus, as if the awkward moment with Judge Rushing never happened. She methodically answered every legal and factual question from the judges, always going back to the main principles at stake. As she finished, she made a point that would resonate beyond the courtroom. "Your Honors, this case comes down to a simple question. When a state passes a voting law that it knows will stop hundreds of thousands of eligible voters from casting ballots, what compelling reason justifies taking away those votes? The state has mentioned possible fraud, but hasn't shown any real fraud that this law would prevent." She gestured to Emma Johnson in the front row. Ms. Johnson fought for voting rights in the civil rights movement. She has voted in every election since 1965. She has a driver's license, social security card, Medicare card, and decades of tax records proving her identity. Yet, because of a fire in the 1970s that destroyed her birth certificate, she can't vote in the next election. Crockett paused, letting the impact sink in. The Constitution promises equal protection under the law. It's not equal when some people have to overcome impossible obstacles to use their most basic right. As Chief Justice Warren wrote in Reynolds versus Sims, the right to vote freely for the candidate of one's choice is of the essence of a democratic society, and any restrictions on that right strike at the heart of representative government. With that, she thanked the court and returned to her seat. The court was silent for a moment before the chief judge called on the state's lawyer to present their response. The state's argument, while professionally delivered, was met with a much different reaction from the judge. They grilled Crockett with tough questions. Now, they pushed the area's lawyer about the lack of evidence for voter fraud, the mandate's unfair impact, and how bad the waiver thing was. Get this, Judge Rushing asked pointed questions about whether the area had even looked at how many eligible voters couldn't meet the mandate before they put it in place. The lawyer admitted they hadn't, and she followed up with a question that shocked people. Doesn't basic fairness say the area should see how new voting rules affect people before making them law? It was a total flip-flop from what she said before. Suggesting Crockett's respectful but firm answers made her rethink her approach. After the session, legal watchers exchanged surprised glances. Something big had happened. A judge who seemed set in her ways openly changed her mind after hearing solid legal arguments and facts. Outside the courthouse, reporters swarmed Crockett, wanting to know what she thought about the rare exchange with Judge Rushing. Instead of blasting the judge or bragging, she stayed professional. Today's session was about the basic right to vote, she told the media. The judges asked thoughtful, hard questions that got to the heart of the matter. I'm sure they'll carefully consider everything before making a decision. When a reporter pressed her about Judge Rushing's statement, Crockett played it cool. Judges often check arguments with tough questions and comments. What matters is protecting every eligible resident's right to vote. That's what Ms. Johnson and others like her deserve. She didn't make it personal or act like a victim, even though the judge had clearly gone too far, which impressed legal folk of all types. As a CNN legal expert said later, that wasn't just good lawyering. It was a masterclass in professional integrity under crazy pressure. 3 days later, the appeals court released its decision, shocking court watchers. By 9 to 5, the court blocked the birth certificate rule for the upcoming election. Even wilder, Judge Rushing was with the majority. The opinion, written by Chief Judge Gregory, cited past cases, saying that if a voting rule puts a big burden on many eligible voters, the area has to prove the rule is narrowly designed to address a real problem. The court said the area didn't show enough evidence of fraud to justify stopping thousands of eligible voters from voting, so it ordered the area to accept other forms of ID for the election. But what really blew the legal world away was Judge Rushing's concurring opinion. She wrote something that will be quoted in law schools for years. While I've always said areas have broad powers over elections, this case shows a rule that basically denies the right to vote to thousands of eligible residents without a good reason. As judges, we have to be willing to rethink our assumptions when presented with strong evidence that challenges them. The evidence here shows that birth certificates, unlike other IDs, create unique and often impossible problems for some voters. The opinion continued, equal justice under law, the motto on the Supreme Court itself, demands that we look not only at how fair election rules seem on the surface, but how they actually affect residents' ability to use their most basic right. After looking closely at the advisor's proof and arguments, I don't think the region's worry about avoiding cheating justifies stopping thousands of qualified people from voting. News sources across the board pointed out how unusual it was for a judge to so openly rethink her view. Judge Rushing's change of heart shows something increasingly rare in our divided legal world, wrote the Washington Post. One legal expert said she's willing to follow the proof and arguments even if it questions her first ideas. The result of the Fourth Appellate's ruling and Judge Rushing's surprising switch had a big impact, going beyond just this case. In a few days, 3 other regions with similar laws in the works said they would rethink them, mentioning the court's look at the real-world problems that birth certificate rules made for voters. News coverage of the decision really focused on the dramatic back and forth between Crockett and Rushing, with legal commentators from all sides noting how Crockett's response showed the best parts of the legal world. Clips of the moment went viral, getting millions of views as people saw a rare case of serious legal debate changing a judge's mind in real time. For Emma Johnson and other voters like her, the impact was quick and real. With the birth certificate rule blocked, they could now vote in the upcoming national election using other IDs like social security cards, Medicare cards, or other official papers. Johnson told reporters, "I marched for voting rights in the 1960s. I never thought I'd have to fight for my right to vote again in 2025, but Representative Crockett fought for me, and I'll always be grateful." 2 weeks after the ruling, in a move that shocked even court watchers, Judge Rushing did something very rare. She spoke openly about the case at a legal event. Judges usually don't talk about specific cases, especially recent ones, but Rushing clearly felt she had to address what had become a big topic in legal circles. "As judges, we bring our legal views and life experiences to the table," she told the gathered lawyers and judges, "but we have to stay open to proof and arguments that question our beliefs. Lately, I've been reminded that real legal judgment needs not just smarts and honesty, but humility, being willing to rethink our positions when strong proof calls for it." She went on, being remarkably honest. "I came into that session with certain views about the facts and the law. The supporter's presentation of proof and legal example made me rethink those views. That's not weakness. It's what the legal process is all about. If we can't be swayed by proof and good arguments, we're not doing our main job." Her words, widely reported in legal news, sparked conversations about legal courage and the growing rarity of public figures admitting when they've changed their mind. Law professors added the case to their courses, using it as an example of both strong support and legal honesty. For Representative Crockett, the case boosted her already big reputation as a successful fighter for basic rights. But instead of using the win for political gain, she kept pointing to the bigger issues at stake. "This case wasn't about people or politics," she said in a C-SPAN interview. "It was about making sure every qualified person can use their basic basic right to vote without facing impossible challenges. Judge Rushing's willingness to carefully assess the proof shows the system working as intended. Crockett won points with legal experts across the board for how she went after the law and facts, letting them guide her. She didn't try to brag or slam the judge who wasn't originally on her side. The American Legal Association liked her approach so much, they asked her to give the main speech at their yearly thing. She talked about keeping things professional and sticking to basic legal ideas in a world that's getting more and more divided. Her speech, called Beyond Doctrine, Basic Support in Divided Times, became required viewing at law schools all over the country. It's easy to see legal fights as just politics, she told the lawyers, but the basics are bigger than that. If we stick to those basics with good facts and respect for our system, we can bridge divides that seem impossible. She ended with words that would get a whole generation of law students fired up. The best tool for sticking to the basics isn't fancy words or legal theory. It's being ready. It's the hard work of knowing cases inside and out, getting the facts, and laying out a clear path for courts to follow. It's not glamorous. It happens in libraries and meetings, not on TV, but when it's time to stand up, that readiness becomes power. Maybe the biggest praise came from Judge Rushing herself. Half a year after the ruling, at a legal meeting about competition law, someone asked what had influenced her thinking on voting rights the most. The Johnson case really opened my eyes, Rushing said. I always knew voting was a basic right, but the real world proof in that case showed how rules that seem fair can actually deny that right to some people. Representative Crockett's work reminded me that equal protection means looking at not just the rule itself, but how it works in practice. But the story goes bigger than just this one case or these two people. The interaction between Crockett and Rushing, caught on video and watched by tons of people, showed a different picture than the increasingly negative view of the U.S. legal system. At a time when many Americans thought judges just decided based on their politics, they saw a rare example of someone actually changing their mind because of facts and good arguments. Law schools added the case to their teaching plan, using it to show students how to deal with tough questions without losing their cool. Government experts pointed to it as proof that real legal arguments can still overcome political divides. Legal scholars said Rushing's agreement showed how sticking to the text and caring about real-world results can go together. For everyone else, the case offered something rare, an example of how things are supposed to work when people act honestly. The idea of a traditional judge rethinking her position after seeing convincing evidence from a progressive supporter suggested that common ground is still possible, even in the most divisive situation. As one analyst put it, when supporters present facts and legal ideas well, and when judges are really open to proof, our system can still deliver equal fairness. The ruling on voting rights had a ripple effect far beyond the immediate case. After the decision, places thinking about new voting rules started checking how those rules might impact different groups before putting them in place, looking to see who might face unfair challenges. Some places even changed their proposed rules to allow for more exceptions and different ways to prove who you are. The Fairness Authority started asking for these kinds of impact studies as part of their reviews in places still under the old Voting Rights Act. For Emma Johnson, this meant a lot personally. On election day, she walked into a polling place with a social security card, Medicare card, and military record, all acceptable forms of ID because of the court's decision. The poll workers knew her right away since she'd been voting there for years. As she cast her ballot, she told reporters outside, "This is what we fought for all those years ago, the right for every citizen to have their voice heard. I'm just glad I'm still here to use it." The impact of that court case is still felt today. When law professors talk about times when popular opinion outweighed political division, they point to how Crockett handled Judge Rushing's surprising move. When judges talk about examples of real belief changing their minds, they talk about how Rushing was willing to rethink her initial position based on evidence. But maybe the biggest impact is on the thousands of eligible voters who can still vote without facing impossible ID requirements. These are citizens whose basic rights are protected, not because of political gain, but because standing up for principles and judicial integrity allowed our system to work the way it should. If this story of how our legal system can still work when honest people prioritize principles over politics inspires you, please hit the subscribe button and turn on notifications. We bring you the most important cases that often don't make headlines but shape our government for years to come. Share this video with anyone who needs a reminder that our institutions can still work when we approach them with fairness, principles, and mutual respect. The fight for basic rights continues, and we'll be here reporting on the cases that make a difference.